We all know that from July 16th onwards, when the EU CJ ruling came up on what is generally referred to as the Schrems 2 uh, reference, there has been a sort of concern in the marketplace uh, of how this invalidation of the US privacy shield would affect the entire ecosystem. We in India are also concerned because many of the EU companies have working arrangements with US companies, and US companies actually offload their processing work to Indian companies, particularly in the SME sector. So, if the agreement between, I understand about 5,377 companies in US had privacy shield arrangements uh, under which they were importing data from EU. And obviously, now all those agreements will get invalidated and it has to be replaced with an alternative arrangement as provided under GDPR. And consequently, downstream contracts will also get affected. So that is the basis on which we thought we should have a conversation with you. Mm, Perhaps we can start with your perception of what is this judgment of July 16th, which was followed by July 23rd EDPB guidelines. Let us first get your perception on that ruling and also the background of that ruling. How did it come up? You can expand on that.
Thank you very much, sir. Everything, this whole debate about the privacy shield and SEC started with one of the lawyer, is an Austrian-born citizen, but being in Ireland, he had filed a case against Facebook Ireland transferring the data to Facebook US on the ground of for the surveillance and other programs that happens with US. So he had approached the Data Protection Commissioner in Ireland, and what had happened is he had tried to take a ruling to prevent such data belonging to him transferring from Ireland to US, which was very well debated. And however, the preliminary ruling was set aside, and later, post which the matter was initiated before the CGU. Now, this is what we call it as a Scrims 1, which happened way back in 2015, and there was a judgment that was pronounced way in 2015, October, which clearly dictated that the Safe Harbor 1, which is called as the earlier sunrise provision that was set up between the European Commission and US, which was monitored and overseen by the Department of Commerce, was set aside. Now, what happened post that? The European commissioners, the US came across, because the trade is one of the significant matter, as part of which discussions took place. And finally, in 2016, we had Safe Harbor 2.0, which is also called as primarily the privacy shield that was put in place with adequate certain other aspects, which was dictated in terms during the CGA ruling that there are no mechanisms in place where the EU data subjects can raise their claim and address their grievances when the data is being processed with US. So immediately, I think the Michael Scrims had again filed a case, and that's called as the Scrims 2. And this ruling, it was asked for a preliminary ruling. I think the Facebook tried to dictate, stating that when the person had applied this particular, created this profile, he had used consent as the basis in order for the data to be transferred, which was on a derogation. But however, as part of the mid of the argument, Facebook withdrew that particular comment. And later, however, since it mattered more in where it talked about data being transferring to certain countries which are not adequate in nature, it considered to be of a major ruling. So the matter was posted again before the CJU. And on July 16th to 2020, we had the particular ruling where two major issues were cleared. One, It invalidated the privacy shield on the ground of the US surveillance laws that have been in place are not protecting or not meeting the requirements of the regulations, which primarily focuses about the protection of rights and freedom of harm from the data subjects. And on the second point, the same issue was also placed whether SCC is a kind of a document where organizations can use that as a safeguard mechanism in order to promote data transfers. The CJU ruling said there is no invalidation of it. It stands good. However, it left the data importers and the data exporters, that is the entity which is there in EU, and the recipients who are going to be collecting that particular data or processing that particular data, had certain additional obligations to do a mandatory check and assess whether there are any laws in that country which will prohibit a kind of a data or exercising of a data rights of the data subjects. So on that particular stand, directions were issued where under Article 58, the supervisory authorities were being given permissions to see if they could even ban or suspend such kinds of transfers and come out with certain guidances. Now, this is a major ruling. Now, what happened within a week on July 23rd? The 34th plenary meeting was attended by all the supervisory authorities across Europe. And in the particular ruling, the statement was issued by the EDPB clarifying the ruling from the CJEU. At the same time, what are the additional things that needs to be followed in terms of how supervisory authorities and data subjects specifically data importers are bound to comply with the regulations. So this is the overall background from where it started till where are we right now. We are still waiting for a lot of guidances, but this is the current position maintained as part of the EDPB statement.
Now, this US Privacy Shield actually was a continuation of the earlier safe harbor system. Can you just give us a historical background of how US and EU have been trying to work out their differences in terms of the responsibilities between a data exporter from EU and the data importer from US, and uh, so that we can understand the real reasons why the court has felt that this particular arrangement failed the constitutional test in EU.
Sure. Before we get into that, a little bit of background in terms either starting from the EU directive as well as from the current GDPR regulations. So what are the different safeguard mechanisms where a data can go out of a particular EEA country, the European Economic Area, to another country which is outside EEA? So primarily, we have seen in the past 25 years, there are only 12 countries. I think the recent one, 13th, was Japan, which happened to have that initial mechanism which was promoted, what is called as the adequacy mechanisms, where the European Commission looks into the particular organization, particular country's national law, and it tries to compare it itself with its current EU law and tries to determine whether the local country from where the data can be sent is considered to be adequate to exercise, to allow the data subjects to exercise those powers. Now, the second safeguard mechanism is binding corporate rules, which is a mechanism where instead of a country, you have an organization being provided a kind of an adequacy status with its own set of bylaws and rules. Now, any data transfer is permitted within the intra-group countries, which can make sure that these recommendations and measures are put in place. Now, the third mechanism that was appointed was standard contractual clauses. And this is a mechanism where you see around close to 95%, more than 95% of organizations across the world depend on this particular mechanism. Now, US, using its capitalist power, happened to have a dictate a particular agreement, and this is also permitted both under the EU directive, where countries can go approach the European Union, have a kind of a conversation, a kind of an arrangement or an agreement. And based on the agreement, it can come out set of bylaws and rules based on which a safe harbor or sunrise provision can be set up between the countries. So in 1999, the Safe Harbor 1 was approved by the then European Union Commission, and which was also accepted, and later the Department of Commerce in US adopted this for organizations to comply. So Safe Harbor is primarily a self-certification model, but in Safe Harbor 2.0, it also had an additional mechanisms where arbitration and other aspects of grievance redressal mechanisms were set, so that the data subjects whose data are getting processed can approach this particular agency or particular tribunal to address the grievances and ensure that the rights and harms to the data subjects are exercised. So that's how the whole journey from a safe harbor started way back in 1999, which as a lieu of the EU directive.
Now you said Safe Harbor was essentially a self-certification scheme. Now this Privacy Shield also, does it not have a self-certification element? And what is the difference between Safe Harbor and this in terms of the improvement in whatever protection measures were envisaged?
Yes. So as I said, there are two differences. So one, which I said, was about a safe harbor and privacy shield. Both are self-certified. But however, in the privacy shield, one of the major important aspects of where a mechanism or a particular arbitrational aspects was provided, so where the data subjects can go and address the grievance. So if an organization is transferring the data to US, there needs to be also a provision in makes where judicial remedies, at the same time any administrative remedies of grievances, can be exercised by data subjects. So that crucial part was the one that was added to the privacy shield. Beyond that, there was no other major differences between Safe Harbor 1 and Safe Harbor 2. The
You are
second
talking about
aspect
the
of difference is, and this,
ombudsman scheme? Yeah.
yes,
Yeah.
yes,
Hmm.
yes, yes.
So,
So the second part of it is majorly in terms of the enforcement perspective. So if you could go back and look at the Safe Harbor 1.0, the organizations used to just apply a form of self-certification, but there was no much kind of an oversight from Department of Commerce. But post CGA ruling in 2015, if you could see, the organizations are being regularly scrutinized, and their effectiveness in order to continue the privacy shield certificate are being regularly tested by the organizations in US. So that's the two major difference I could say between Safe Harbor 1.0 and Safe Harbor 2.0, which is called the Privacy Shield. Beyond that, there is no much kind of a huge difference between the way how it works. The principles continues to remain the same, and and the mechanism in addressing this or renewing the applications and all those things continues to remain the same.
now, what has been there in the Japanese system, which brings them under the adequacy, and which other countries like, let's say, US or perhaps any other country doesn't seem to have?
If you look at the Japanese Personal Information Data Protection Act, which it came into existence, and it is very stringent, and in terms of exercising of the rights, the Japanese law clearly provides that kind of a mechanism whereby the any data being transferred to a country like, say, not only Japan, to all the other 12 countries where adequacy has been recognized. So that particular is a key crucial factor, which also talks very clearly in terms of how a particular country can go and adopt its mechanism. So if you could see when the particular countries like Philippines and Singapore, which is already in the line in terms of getting a privacy in line of getting an adequacy recognition, the Philippine law is much more stronger. Whereas there are certain key aspects that have been missing in Singapore, which talks about the data protection breaches, how breaches are notified, and how the grievances can be redressed. Because if you see, the Singapore data handles only about the Singapore citizens, but any data being processed in Singapore belonging to outside falls outside the scope of the jurisdictions. So these are some of the key factors which Japan was able to address in its law. And in the recent amendment also, they have exercised more kind of a provision that could let to consider Japan as one of the adequate country equivalent in name with the European Union law.
Okay, now there is also something called a Swiss US Privacy Shield, okay, which I understand will
Yes.
continue despite what has happened to the EU Privacy Shield. Now, how do we interpret that?
So, either on this after this Krems one ruling, even though the Swiss US, because Switzerland is a particular country which is a free trade association, which but parts form of the European Economic Area. So, a mechanism at that point of time to allow data transfers from Switzerland to US. That's how the safe harbor provision came in after the EU-US safe harbor was discussed about. But however, after the ruling in 2015, in 2017, the European Commissioner, the Switzerland Commissioner, that is the Data Protection Commissioner of Switzerland, were able to make certain major changes in line with Privacy Shield to the EU with regard to the Swiss US safe harbor provisions. So one of the reasons why I would see it continue, we can come to a major change is only once when we have the Switzerland Act comes into force. Because until now, the Switzerland, we only see the 1992 Act, which is still in place, and it is still not adopted GDPR as part of its national law. There are a lot of many discussions are continuing as we speak right now, and the initial phase was to see in September a kind of a draft provisions, some major discussions happening in the Senate. We already have a GDPR related law draft available in the database way back in January, but the COVID reasons have significantly pushed a delay, causing delay to this particular implementation of the act. So probably we're looking at sometime next April 2021, we may have, and it's only post that we'll be able to come on to see how the provisions of the Switzerland US safe harbor in line with the local law, that is the revised implementing GDPR law, we may see a significant changes. So I'm sure this is also going to adopt the same mechanism as of what the European Unions are going to come out with, but it's a wait and watch to see on that.
Is it possible for UK also to enter into some separate privacy shield arrangement now that anyway it is part of the Brexit?
As part of the information I was able to retrieve, currently UK is discussing about the adequacy status with the European Commissioner, and it is also part of the current bilateral trade discussions in terms where the European Union, it works along closely with the European Union to go out of European because of the Brexit scenarios. So definitely adequacy is there. And the recent statement issued by the European Commissioner while discussing on other major provisions that applies as part of the Brexit, data protection was also part of it. And recently he made a comment about looking at some way kind of a deadline where UK could reach an adequacy status, provided it can meet the general criteria of uh, the European Commission's eligibility requirements to get that adequacy. And as we see the Data Protection Act 2018 of UK is significantly very much similar, at the same time much more stringent in terms of applicability and in terms of the enforcement powers. Meanwhile, it's one of the wider supervisory authority in the world, which comes with significant guidelines, significant areas of growth, and they are very much proactive in nature. Connects to California, as I've seen in my past 10 years of my privacy domain theory. So I'm sure that it is way near in the future, UK will achieve the adequacy status if it continues the same, and it is definitely part of the trade negotiations of Brexit.
Now, say GDPR anyway provides for individual member states to have some kind of their own laws. Does it mean that if Switzerland and UK are capable of getting separate trade agreements with US to bypass the GDPR restrictions, is it possible that other EU states also can think of a similar route so that the GDPR implementation to some extent gets dissipated into individual member state regulations?
See, if you look between provisions between 45 to 49, which primarily addresses about general data transfers, it does provide a mechanism for the supervisory authorities in the particular country within the European member to enter into a kind of an agreement or also come out with their own draft of the standard contractual clauses, which can be used by organizations to permit the data transfers. But however, I would find it unacceptable from the fact that the entire GDPR, entire privacy laws, which are based on, as we go back on the Article 7 and Article 8 of the Human Rights Conventions, the European rights as well as the UNHR, uh, I significantly feel that would be one of the significant issue which will be negotiated, and that could be one of the roadblock to promote such kind of arrangements specifically with US, unless or until the country can come out forward and provide a kind of a mechanism where the data subject rights, which is expected, where there are undue interference from the local organizations or the supranational authorities, which are into a huge surveillance scams. So, in the name of national interest, the FISMA and other regulations, which does happen, I think that's going to be one of the significant roadblocks to have some kind of an arrangement in that way. But yes, the authorities can do, it can create a mechanism, but I don't think the baseline of you know deviating and overruling the data subject rights will become almost kind of unconstitutional if it definitely the authority steps in. And in that case, I'm sure the European Commission would also step in, because I don't think the countries would be allowed to have some sort of a trade arrangement which can significantly alter the basic preamble of the requirement of the privacy law.
Okay, so if you look at the judgment of this July 16, one of the reasons which the court has taken for overriding whatever agreement, because this was actually an agreement between the EU Commission and US, and at that time they had discussed all the privacy principles, security safeguards, and all those things. Not that it was just signed by an irresponsible entity, but the court actually overruled that basically because they felt that the data importers in US will not be able to resist the instructions, statutory instructions or of interference coming either from the President of the United States or the Secretary of State, and even the ombudsperson who is going to be appointed, who has already been appointed, is reporting to the US Secretary of State, and therefore is unlikely to be able to resist any interference request. So this was actually the crux of the matter. The court felt that the US authorities, like the ombudsperson and of course the data importers, are in no way capable of resisting the interference demands coming from the intelligence agencies headed constitutionally by the President of the United States. Is it correct to say that the court was not happy with that kind of a situation in the US?
Yes. So the court, even after specific, it went into the details. It was able to find that at any point of time, the US laws were not able to provide that kind of mechanism to protect an individual's data subject rights. I mean, after significant discussions, we did find some of the laws which were already, which was very clearly stipulated, as part of the judgment, which clearly dictated the fact that there is no control over the data that is going to US, which can which cannot be touched by the agencies. So the agencies has its rule, and such interference, it always the law consider that it is a violation of an individual's rights. And as part of that, yes, you're perfectly right. That's the understanding from the ruling.
See, now that this privacy shield is off, uh, the standard contractual clauses have come to the fore. BCR also has been specifically stated that it is unlikely that it will get full endorsement, because that will also suffer from the same infirmities which has been pointed out in the judgment. And probably the standard contract clauses also, which impose us certain contractual restrictions on a data importer in US, and uh, that also is subject to the same infirmities. And of course, the EDPB has escaped its responsibility by stating that if a situation arises like that, data importer can send a notice back to the data exporter saying that I am unable to, perhaps resist a particular request or something like that. So the responsibility has been shifted from the data exporter to the data importers to confirm or assure that they will be able to have a standard contract clause arrangement, and also be compliant with it as per the directions of the court. Okay, so why can't we expect the data exporters to take more responsibility? Why is that the industry is accepting a situation where data importers are assuming responsibility under the SEC? And also, when US companies transfer such contracts to India, trying to incorporate the same SEC clauses in their processing contracts, so that somebody sitting in India is giving today an agreement saying that I will be able to resist any interference from my law enforcement authorities, failing which I will give you perhaps a notice or something like that. Don't you think it is an unfair way of shifting responsibility from EU entities to non-EU entities?
So, a little bit of where I would like to beg to differ here is, if we look at the ruling has clearly set out that both it is primarily the data exporter who will need to do an assessment, keeping in mind what kind of local laws and are there any local laws that can interfere with an individual's data subject rights. However, I think the part that you did mention comes with the fact that yes, currently I did the assessment. I found that it is specifically meeting certain requirements. I have put some additional administrative safeguards in place, and any other additional measures that the law would like to, any guidances that will come from the supervisory authorities. So I post that I transfer the data through an SEC, and in that particular process, as part of the processing, if at any point of time it finds that there are certain new laws, I mean, like the one that which we saw in US, the Cloud Act, which started having enforcement powers in the mid of the provision. So such kind of a legislation, if there is a kind of an impact that could lead to, uh, getting ruling out, I mean, not meeting with the requirements of the SEC, it is only in those cases the data importer is expected or obligated under the law to notify us and ensure that if the additional measures can't be met, they have to uh, prohibit any further processing, and all the data needs to come back. So this is my understanding from the ruling, and I'll be happy to hear views, but this primary accountability rests with the obligation on the data exporter to do the kind of assessment prior to such transfers. So while doing that, if it finds it is sending to a particular country where there is no clear laws, there cannot be controls that will put in place which will not help in meeting the expectations of the regulations. So it is the data exporter who should not process the data in that particular third country. So that's the way I would read the judgment.
See, the SECs have one peculiar provision where it says that if the data exporter is absent for some purpose, he has vanished, then the data importer will almost step into the shoes of data exporter in terms of providing any kind of data rights obligations being carried out. So data importer says that I will take care of the access rights, I will take care of the other rights of the data subjects. Uh, and this data importer is not a EU person. Now the EU person has defaulted by a data exporter who has perhaps gone into insolvency or simply vanished. It might be a fraudulent data exporter also from EU. But in such cases, the standard contract clauses appear to somehow shift the responsibility to the data importer. Now, in such a situation, in fact, I am sure that you are aware of that particular clause. If the data exporter is no longer available or something like that, does it not actually invalidate the contract between the data exporter and the data importer itself? How can we expect the data importer to take the extra responsibility? This is from a legal point of view.
Your question is perfectly correct, but from a devil's advocate point of view, when I look it from another end, I look at as that if the entity A which had transferred the data to entity B, and if the entity A is no more in existence, until or unless the data is moved back or some kind of mechanism, there should be some other entity which is holding the data should be held accountable under the law. So I would like to consider it in that way, that if there is an abandonment or a kind of dissolvency by a particular entity which has actually transferred the data as a data exporter, and the data is in possession with the data importer for processing. So by law, be a part of executing the SEC, the data importer is also held liable to see to that. I mean, most cases, if you see the way how the laws, and this existed even before GDPR, we know under the GDPR, the processors were also held liable directly in terms of administrative penalties. But if you see in the EU directive, the laws primarily held primary accountability only to the data controller. So I think the FCC's adopted this phase, and from a different perspective, and where I see it as a point where when that one entity which has transferred disappears, at least the entity which is holding the processing, the data which is holding the data should be legally bound in the contractual terms, and that's what I feel the SEC has tried to adopt. It is a probably a different every there can be different thoughts to it, but the way I see it in that way.
See, the consent has been actually obtained by the data exporter. Data importer may not have the consent. He may not even have a verifiable information about the data subject. In such a situation, how can the guidelines of SCC expect a data importer to actually accede to any stray request he may get for access from somewhere? Because fundamentally, in a situation which this SCC clause is anticipating, we don't have the data exporter available for sharing the consent form and even the verifiability of the data subject. And that being absent, the responsibility of the data importer becomes very onerous because he may end up giving the information to somebody who is not entitled to receive that information.
So, when we talk about data subject rights, when we talk about data being handled, I mean, there are mechanisms of other provisions under the GDPR and other legislations which apply to even to a data importer, because without validation, probably the data cannot be responded. So I would kind of feel like a privacy program to be managed by the data importer in handling such queries instead of just it can be a onerous responsibility, but that's kind of a thing that you enter into when you are signing an SEC. So which I'm sure in practical per se, most of the organizations which are signing SECs, they sign multiple SECs, but I'm sure not even once an attempt would have been made to really read to the provisions that they agree, because they feel it is just a checklist item just to fill the Annexure 1 and Annexure 2. And even if you see the Annexure 2, the technical organizational measures which have been signed, uh, people have no clarity when they sign an MSA with technical measures and signing an SEC with technical measures. There are two different significant items. A lot much things. So from an awareness standpoint, a lot of uh, organizations doesn't understand this. But however, saying or not, once you sign that, you do accept that kind of accountability, and it is definitely it is an organization's responsibility to ensure that the data subject rights needs to continue to protect. So I think this will come as part of an aftermath, but it goes without saying. I mean, the clear provisions of the law that what kind of accountability they enter into.
Say sometimes the companies in India may be willing to sign the SEC contract for business considerations without reading too much into the clauses, thinking that only there's only contingent clause. But for GDPR consultants like us, when the client refers that contract to us and asks us to clear that contract, we get into a very embarrassing situation of having to approve a contract which we know is not fair, which we know that this client will be unable to perhaps employ with on a later date. But as a consultant, I have to put my approval on that. It becomes difficult. So that we also try to qualify like auditors and others. And normally we suggest that put a disclaimer clause somewhere in the end of the contract, notwithstanding anything stated there, we will be bound by Indian contract, Indian laws, because that is the only umbrella which we have to take. Of course, our information, the data protection authority can bring some kind of a relief to this, which I had been suggesting to Justice Sri Krishna even when he was discussing the basic law, but it has not yet come to the PDPA. I wanted to have a sort of an umbrella coverage under which any external countries' data processing contracts and their implementation, there should be the DPA should become a sort of an ombudsperson kind of a thing, and through him only it has to come. Like in criminal laws, we say if you want to take action against a government officer, you have to get the permission of his higher authority, something like that, no, like that. But that has not happened. But anyway, now looking at the alternatives which are available now, that US Privacy Shield is gone, BCR is doubtful, SCC has got its own difficulties. Now we come back to the alternatives beyond this, and in my view, we feel that we have to explore this explicit consent for transfer as one of the bases on which the data exporters should actually ensure that data gets transferred, because the data exporter anyway has to satisfy himself about the data importer's ability to safeguard the personal data. So we hope that he will be confident about a data importer with whom he wants to have a business dealing. But having taken that view of even, let us say, an audit or a background check on the data importer, the data exporter should be able to tell the data subject that I have verified the credentials of whomsoever I will be appointing as data importer. So don't be worried about that. Give me explicit consent to transfer the data out of EU. And that way, I think we will be able to overcome the difficulties which we are seeing now in the even in the SEC. What do you say?
There are 2 points, Naavi sir. When we talk about explicit consent, it is it's a double-edged sword. Okay, it can be a perfect mechanism for you to allow a data transfer or processing under the law, but it has its own challenge when it comes to when you take an explicit consent. The consent can also be withdrawable by the data subject at any point of time. So normally from EU, consent as a mechanism is always proposed as a last choice, and specifically from an employer standpoint and employer-employee standpoint, it becomes much more worse because in some of the major contractual term, I mean, even from an Indian contract perspective, from an undue influence or coercion, those can be invalidated. Now, saying this, is consent the only choice? I would suggest probably we need to also look at other part of the other derogations available in Article 49, which also talks about where you can transfer the data specifically for online services, where as a performance of a contract as a legal basis, you can still transfer the data. or if the particular data, and will you do that, it should not be, it's not to be occasional in nature. It's a one time or a use. Now, coming to the other mechanisms, is one is for the vital interest of the data subject, another one is the public interest of the data subjects. So, public interest, it can serve. So, there are several other mechanisms, but however, an organization choosing the right legal basis has its also own challenges. It also has its own limitations. When we and to your statement about giving the data subjects clear explicit provisions that we have done, I think the transparency provision very clearly states, when you are disclosing people, when you are actually notifying the data subjects, that in the one of the requirement is for you to very clearly state that this data will be disclosed or used by a third party. And when we talk also about performance contract, or more from a legitimate business interest, the legitimate business interest of not only a data controller, it can also be a third party. So if there is a legitimate business interest for me to transfer the data to a third party, however, keeping in mind the rights and harms that may cause to a data subject is not much violated, I think in those mechanisms or these derogation requirements, you can still transfer the data. But it's a huge challenge keeping in your mind, because when we talk from a consent perspective, it puts a huge challenge on the organizations, and sometimes in most cases organizations fail to meet the eligibility criteria specifically laid out under article 7 of the GDPR. Sometimes if it is transferring, say, example of Facebook or any kind of online services, and the data, when such provisions or consent is obtained as part of the contractual document, you are actually violating Article 7, Para 4, where you are binding both the privacy and the contractual terms, and as a result of which the data subject who is providing his consent doesn't stand in the court of law. So there are huge challenges on consent. I think either the mechanism should be legitimate business interest or a performance of a contract, or it should go back to SEC. I don't think SEC is going to be ruled out. The next thing what we may see is already the SEC draft in line with GDPR, because we currently use still the EU directive template, which was approved in 2004 and 2010, and still it adheres to the Article 25 and 26 of the EU directive. So I think we are going to see significant change, but the significant change would come more in terms of organizations conducting prior assessments before we go and approach for any other means of other data transfer. So I think it's going to be primarily accountability is going to be one of the major principles that we're going to apply for the organizations prior to having any kind of transfers.
Okay, I understand your viewpoint, though I personally feel that we should bring pressure on EU data exporters to take more responsibility in terms of this concept. In fact, forcing the downstream contractors because of the economic strength a data vendor has got will only lead to somebody signing like a dotted line contract and later on claiming that I was under. That is the same thing which happens in employment contracts. No, many times people will later on say that I had no other option to accept, kind of a thing. In fact, I have actually tried to bring it to the attention of the Indian authorities like the ministry that Indian companies executing such standard contract clauses which are violative of Section 69 of Information Technology Act is something which they should take notice of and see what has to be done, because Section 69 gives certain powers for the government to, let us say, get some information, whether that information is of personal data or non-personal data, whether it is Indian citizens or foreign citizens. In any case of cybercrime investigation, the government has got the power, and that power is what the SEC is trying to restrict, and that is what the EU has found fault with in this particular judgment. So today we cannot say we don't know that. We are aware that GDPR data transfer agreement means that I am aware of this EUCJ judgment, and whatever I am agreeing to is in that context. So somebody outside the industry from the government has to move in and start negotiating. In fact, there's a question from one of our friends here, Dr. Lemay. What do we expect the US to do now? How are they expected to react? Are they going to renegotiate, or are they going to make changes in their ombudsperson's structuring? Will they bring, let us say, a judicial authority there, make it independent, at least on paper, that he will not be answerable even to the President of the United States? What do you expect would be the reaction of US?
So, US has already reacted. Even in the past 2 weeks, it has already sent two notifications where it continues to hold the legal viability of Privacy Shield, and it has also asked people, the organizations, to go make sure that if there are any renewals to be made, to continue to do that, significantly showcasing to the European data on the validity of the system which is already put in place. So Privacy Shield is still on for US. It might have been cancelled or invalidated by EU, but it still continues. Department of Commerce, even if you go right now, it will provide you how you need can recertify. It allows you to go and make your own self certification and register with the Department of Commerce. And US in the second notification is also very clearly stated that it will continue to have a better relationship. It will continue to have a conversation with the European Commission to make sure that they will have something ruled out. Why could be one of the simple fact, because the CJA ruling has also questioned the validity of SEC to US as well. So as a result of which, it needs to do something very much, and already negotiations have started on that particular front. Now, how it is going to change, how it is going to apply, because I'm sure the European Commission would also will have some kind of a mechanism that might come in, which come with an interim to allow such kind of data transfers, because the other two basic models which can be only preferred, either the adequacy decision or the BCR, is not something that you get at overnight, and there's going to be a significant impact to trade. I mean, in order for you to get a country to get an adequacy, it will have a lifespan somewhere between 2 to 4 or 5 years. Whereas if you're going to apply for BCR, it would be a 2 year long journey, and it may cost you significantly somewhere close to around 400 to $500,000. So it's a huge cost, huge burden, and the process is very, and it also increases the complexity. If the particular entities are having multiple existence in different Europe. So as a result of which, your application you file for BCR has to reviewed by each and every other authority before it gets, because the lead authority status that you are going to choose will have to act based only once. It's something like we have. If the Central Bureau of Investigation needs to do a kind of an investigation based on an order, you need to also have an appropriate state approval as well. So the same grounds, when a lead authority is also initiated, but there are some kind of internal administrative workflow based on which the lead authority can act, provided the other authorities are also giving a sign off, because each country has its own. There could be separate derogations which you would have adopted as part of the national law. So there's a huge challenge when it comes to the BCR. So I'm going to be positive about it, that in the next 3 to 4 months there's a kind of some kind of positive arrangement that will come in, which will talk about some other mechanisms being proposed. But right now, SEC will continue to play a major role until or unless organizations are picked up and assessed in terms of how the SEC is signed. But if that point is picked out, I don't see any organization spared, because all the organizations who have signed the SECs uh, have not have no clear understanding of what it can percolate down to. So that's something which would
See, in the
would
past,
be.
there have been a couple of occasions in which jurisdictional issues have been raised between EU authorities, basically the judicial authorities, and US, like the old Yahoo Nazi memorabilia case, as well as maybe in the recent days the Google cases. where the judgment of a EU court has been contested as whether it should be restricted in some sense, not made applicable to the US company, particularly in its operations outside US. Like in some cases, we have said that if the website is in a language like French, then French law may be applicable. Otherwise, in English website, it may not be applicable. Search engines in this CNIL, I think, gave that kind of a thing. This certain restrictions may apply to search engine results appearing in EU, but the same thing will not appear outside the EU. So such jurisdictional conflicts, do you feel will arise when the standard contract clauses are disputed? Maybe one court in EU says that there is a need for administrative fines, and he will immediately go to the US court and say that I should be protected. Do you anticipate such legal conflicts?
Definitely. I mean, because unfortunately, the legal systems across, I'm sure India is also no kind of an exception. I mean, you have seen several arbitrational matter awards that have been enforced on outside on a foreign arbitral tribunal. Challenges in implementing it and enforcing it in India. I mean, so I think that's a common legal issue that you will see across any countries. And There are a lot of discussions that are going on, and recently in terms of sharing criminal data, I think GPEN, the Global Privacy Enforcement Network, has been set up. So we need to see some kind of that kind of an arrangement that can come, which can settle some of the variations that may cause from a local legal system. But I'm 100% sure this will continue because these are grounds which are left to the local court, and local court has all the jurisdictions to apply what is the local law of the country, and in that case these differences would definitely continue.
See, one more question just come from Mr. Babu Raj is that from the processor's perspective in India, should they wait for the contract amendment by the controller to align with the new SEC or whatever is that, or is there anything else which they should do proactively?
So my advice could be is a proactive engagement, because we need to keep in mind what the GDPR is. GDPR is not all about a data exporter or a data importer. It's more about a data subject. And if you are doing something where you are processing a data which could lead to an impact to a data subject, contractually or from a legal standpoint and the GDPR, processor can be also directly accountable. So I would recommend a proactive engagement with processor, insisting the controller to have those necessary clauses introduced. Also, kind of go and revisit some kind of engagements where the processing has been carried out, and specifically in sectoral jurisdictions where it could impact based on what the CGA ruling is at. So I would suggest recommend a proactive engagement more than a reactive engagement.
Say, a few years back, I was actually trying to convince the government that there is a need for us to create a sort of a privacy island in India, more or less like a separate processing area where certain laws of India will not apply. Okay. Now, if you see the PDP bill has provision of section 37 where certain by notification the PDPA can be exempted from a particular processing activity. Now, looking at this particular judgment, if India notifies a particular zone like our DIFC kind of a thing in Dubai, or say a particular company's ODC as a zone in which PDPA is not applicable under section 37. In addition, if they can take a stand that we will try to see that Information Technology Act also perhaps will be very sparingly applied. I don't see how any government may say that I will completely give it up, but some kind of an assurance if they give that anyway we are dealing with foreigners' data. I am not that much concerned unless that foreigners' data interferes with the Indian law enforcement. So in all such cases, if there is a new mechanism introduced where perhaps a zone of processing is created with less interference from government, do you feel that is the way to look for adequacy of zones, not adequacy of the whole country, but adequacy in specific zones?
So it's a very unique idea, but my only challenge is how applicable it can be to a data subject where personal data of a particular individual is being processed. I find from that perspective, it may not take through because I'm sure this has a lot of reasons beyond law. It can also business. It can violate some of the other provisions under the constitution. So it's something that probably I always thought of because something which you spoke 10 years back is now a reality. So I can wait and watch for another 5 years. Probably this could become a reality, but
Okay, okay,
I
okay.
can't.
Fine. Okay. Mr. Shreyas Parvate has, of course, a question. Has cancellation of Privacy Shield achieved its objective of restricting or preventing EU data from government surveillance? Do you think so?
Answer no,
Hmm.
no, because the local
Okay.
law continues. It's a most of a political trade. Let us understand that. Similar to US, we have I think Berlin Commissioner also notified countries like Russia, China, even India, which is born to surveillance, major surveillances. We also, if we talk within Europe itself, the countries like France and Germany, they do much more larger surveillance than what we are referring back to US. So it's almost like a political trade war. I'm sure, irrespective of the fact, we may definitely see a Screams 3, which will again come. Significant decisions, but these, I would say, these are some of the milestone journeys for a lot of privacy professionals to see the different side of a particular coin and try to understand and how do we reflect it from a data processing. Because I'm sure till date nobody would have given a significant view to SEC. Uh, uh, I'm sure a lot of people still doesn't understand what SEC, how SEC is different from an MSA, and why do we do sign that. And a lot of people would still doesn't understand the difference between an SEC and a data processing agreement that is expected to be signed under Article 28 of the GDPR. There are two different aspects to it because the scope of an SEC limits only when the data being transferred and that belonging a personal data, and on that risk what is the technical controls. It doesn't ask you to, but what you see, the technical measures that are put for an entire MSA, which could cover a rate card, it could cover an MSA, could cover a proprietary information, intellectual property, all those technical measures you will see it in SEC, which is significantly you're overstating of some of the controls, which are not the right way to have a logical documentation. So tomorrow, if your audit team is going to do an audit, what is the basis or checklist where they're going to do an audit for DP compliance is very different from doing an account level compliance. So there are a lot of things. So probably these are some of the journeys for us, which we can take across in organizations to create an awareness and um, lead preach this to most of the individuals who are significantly talking as just kind of a compliance checklist document. Uh, for me, this is kind of an entirely different subject altogether.
So we are looking for some major, you can say, rethinking in the whole process. So that is one of the, you can say, changes which we can look forward to anyway. Now, one more question, which is, how will this laws like HIPAA and FCRA likely to implement, I mean, impact the SECs in US, and at least in the US context?
No, so SECs are applicable only when you talk about the European data moving to US. So we would have a lot of US clients who are processing the data of Europeans as part of the day-to-day business. They could be either fall under a healthcare providers. So there are a lot of medical data, medical records. I think the mechanism or the legal basis in most of those cases would not be just an SEC. I'm sure organizations who have chosen it would have other legal basis for having this particular data being transferred. So when we talk from a performance of a contract perspective, you cannot process special categories of data. So special when you are handling special categories of data under the European law, you cannot choose a legal basis of contract as a 61B, which is your performance of a contract. So instead, you will have to either choose the 9 to A, or you should definitely choose any of the remaining other provisions, but that's something which is more subjective and applicable to a local EU member state entity. So HIPAA has its own applicability. I think along with SEC, we can also see contracts like business associate addendum. There is, for a local entity existence, there are certain things which needs to comply. One of the significant example we can talk about. We may have entities here, we may have branches across Europe, but for an annual report filing that you need to do it before the authorities, you still need to give all the shareholders, you need to give all the employees whose salary are above more than 60 lakhs or 1 crore as part of your disclosure requirements to shareholders. So those kind of provisions do also violate some of the GDPR provisions. So I think it's a local law jurisdiction, local law applicability. These kind of internal aspects, it is left to how organizations are trying to use other bases to cover it. So I don't think there can be any leeway to waive the applicability of a local law while we talk about an SEC transfer perspective.
Mr. Sanjeev Balodia has some very interesting question. Is there any analysis done from the EU side that European government surveillance does not pose similar or greater threats to the same data?
Um, See, with applicability for the European, if you see European institutions or European organizations from a federal aspect, there are very clear laws similar to GDPR that apply to them. I mean, for example, if ICO is conducting, is for ICO is taking a lot of compliance, or Kennel is taking a lot of compliance where data subjects goes and address. I mean, if you see the culture or the way the particular entity like Kennel admits, before even rolling out that particular program, Kennel does the privacy impact assessments, and these privacy impact assessments are very open and available for public review. Now, when we talk about surveillance, I think it's more from a local law perspective, and in those cases, as I said already, there are countries in EU which conducts more surveillance than any other countries across the world. So, if I have to, in simple answer, if I have to say, is there any clear and concise kind of analysis done? Answer would be no. Or even if it could have been done, probably the report would not have been published. But I'm sure from an internal practice standpoint, they do have a clear, dedicated mechanisms to handle, and it does work like exactly like an organization. Any other data controller, the EU institution also acts like it. That kind of accountability from other authorities outside the world, it's very less. I mean, the only other examples that I could talk about is probably Canada or some other jurisdictions which are very, very dedicated to in terms of falling to the, falling to accept and perform activities as per the true law and spirit. So I would suggest in that way there are very few organizations, few countries who try to adhere to that kind of form and set an example for the other entities within the country to follow.
Yeah, Mr. Niranjan has got one question. I suppose it is from the business perspective. What is the expected business impact of this decision on third countries which are in the non-adequate status? Your estimate, just a guesstimate to some extent.
So, if we talk from the European market, which is involved, we did discuss this when we talked about there's close to 16% market share of 16 of European data which goes out outside, and Europe would host that particular market. So I may not be able to give a clear exact number, but definitely this judgment would leave a road for several conversations coming in, several requirements and compliance requirements, which will have significant impact to certain trades. So specifically, if you are going to end up, uh, for example, if you are using certain applications where the database is located in US, there could be a significant impact where if there are no measures, additional measures can be implemented, then there is a significant need for organizations to shift that to another, either to a service provider or to another database located outside the country. So I think it's too early to give a kind of a trade impact in terms of numbers, but I definitely see there is a kind of an impact for several larger companies, specifically online services and databases, cloud service providers, and telecom having a significant impact here.
Okay. And Mr. Reena Bengal has got a question, which I think perhaps you alluded to earlier. What is the time frame in which we can expect some modified SEC related guidelines or something may come forth?
So SEC related guidelines and additional measures, I'm looking at way the next quarter, we should see some kind of changes, because already the draft, SEC draft in line with GDPR is already was already as per some of my discussions that I had with some European counterparts. I think the CJA ruling was what they were waiting to hold on to it and to see if there could be any major impacts. So I would potentially look at somewhere by end of this year, we could see a significant change to the SEC template, and also in terms of these additional measures, because each authority has to come out, or there should be an EDBB final guidance very clearly stating what are we talking as additional measures. Because if SEC has to be executed, it has to meet some of the three major criterias. One, the infrastructure is supposed to be making sure that there is nothing that violates the local regulations. And if they are, then you need to implement appropriate measures. And in addition to those measures that we talk, what are the additional measures that should specifically be carved out to meet the requirements? I think it has to come in the next quarter. And by year end, we should see some kind of a significant change there.
Okay. And I think we have spent quite some time. And the last reflection from Kodan Raman before I ask Mr. Kodan Raman to actually propose the vote of thanks. He reflects that India is one of the highest data generating country. Today we may talk of 16% EU market share, but going forward we don't know, India may start competing. So should we not think of in some way determining, if not expressed in any stronger terms, dictating or something like that, determining how this kind of transfer of data can take place from one country to another country. Kodan Raman, if you have got anything to say, you can say that, and then
actually,
thanks
I'm
on
not. I would like to add properly, because my questioning was not good. I'm not good at typing, and also on privacy law data, I'm a learner. I'm a late person trying to catch up. My question may look very crude, but I'm looking into a commonsensical point of view. We are being the highest population. When we become the highest generating data, or if we have already become, I do not know, those companies are dependent on our data. We are the major suppliers. When we are major suppliers, why can't we insist on changing the norms, not on the exporters, but all the importers? They before importing, and why can't we on two counts we can do that? That's what I clear. It may be very crude and funny also. Why can't we bring similar law of Indian data going out? Once we bridge it, they are in trouble or whether we will be in trouble. That one first number one. Secondly, by increasing the efficiency of our operations of data analysis or processing, can we not make them dependent on us? So in both way, by avoiding export of good data, saying that you have to, we are not ready. Our law says we are not this one to export the data unless certain conditions, stringent conditions we impose. Secondly, we can increase our volumes of processing in the country itself instead of depending on their data and processing it as an outsourced element. Thirdly, why should we not make an efficient presence ourselves so that on cost wise also we are more efficient and they have to come in search of us. It may be appear crude because this is the only possibility I could see from a common sense of view. Just I want to
A small input. What we are talking is from a trade perspective, but what is from a privacy perspective or the human rights, because privacy falls under human rights, they are entirely very different perspective. So I think the legal evolution that is happening now, kind of after GDPR from CCPA, we have understood the fact that trade cannot be curtailed, but at the same time, data subjects' rights cannot be also overseen. So a kind of a balance. We saw some new things like financial incentives and other stuff that come into picture. Probably that could be some of the best answers and responses to the explicit concern question that Mr. Naavi brought in earlier during the discussion. So I think from a trade and from an individual data perspective, there's a lot way difference to it and the way of looking at it. So I'm sure this is something similar to freedom of privacy and freedom of expression argument that keeps going on. I think this is going to continue, even though Europeans, in most of the organizations which are performed here, the number of European employees or new European citizens, market share is very less, but still it continues to hold hard because of the value that it gives when it comes to privacy. So I think more than data, I think there's a privacy, the rights perspective is given a much of a priority. In certain countries, probably it is the vice versa. An absolute balance, I don't think any organizations does or any countries does exercise that. So for me, that's where I would see there is a clear gray line that has been crossed across, and that could be the multiple challenges where even India to significantly pose. Probably what India can end up is to have something similar like a safe harbor provision, and tomorrow we can have some person who can become the Michael Prince to dispute it. Okay, so that could happen literally, but not something that we don't think that we have a better leeway to talk on privacy because there's a lot much journey for India to pass through. This is my comment, which significantly Mr. Naavi sir will object to it, but we have a long way journey to talk from that particular angle.
Thank you.
My personal view.
Yeah, yeah.
But that is my wishful view. What to do?
Everybody wishes the same, sir. Everybody wishes the same, and it is definitely for as a privacy professionals, it is everybody is expecting that this kind of change happens. That a significant importance is given not only for the country's economic upgrowth, but also from a data subject perspective. And maintaining that balance is one of the biggest steps. Neither from a public citizen and government perspective also is a challenge. Employee is also a challenge. That's the bigger question, $1 million question, that how is that going to get the balance is going to be brought up, according to me.
Yeah, thank you very much.
Okay.
Thank you, sir.
So
I will start my vote of thanks, which I am always feel very sad because this is such a wonderful discussions that are going on. Mr. Rajesh and Vijay Shankarji both are able to give the entire microcosm of privacy aspects of the whole of the world in couple of hours for us, not even 1 hour, 1.5 hours, not even 2 hours. So within that time, we are able to travel such a huge amount of information we are able to get, huge amount of summary things that are happening as on today. I feel this is the right way. In fact, we never got bored with this kind of discussions because we got information from two legendary personalities. One is already a legendary, one is going to become a legendary. I wish him. So on behalf of FDPPI and on behalf of Naavi and on my behalf and all the viewers as of now, I thank Mr. Rajesh Vishwanath ji, all the best and a prosperous time ahead. And Vijay Navji, I seek blessings of you to all our members in addition to thanking you with bottom of my heart. Thank you. And the viewers, you have been very patient on a holiday in the morning. You have spent your valuable time here. For that, from FDPPI and the members, I sincerely thank each one of you. Thank you. Have a great day. Stay home. Stay safe. That's the message for all of us. Thank you.